a question. The merchants in, through there, the Mardi Gras, sometimes the pavement's unlevel and it's real easy to trip on a piece of it and fall down. Who's responsible for that?
That is actually a very good question, and I actually, and Betty, I didn't know the answer to that a couple of years ago, and I had a case in front of the Holiday Inn in downtown Mobile where a lady tripped and fell and suffered a major injury with the broken up concrete. And to my surprise, the city of Mobile actually has a provision with all the merchants that even on the city property, say like the sidewalk that is in front of the business, that the city or the business actually has to maintain it even though it's on city property. Now, it may not be like that in every city or in every area of the city, but I do know that downtown the businesses are required, and it's their, they have to maintain that even though it's not necessarily their property. So even though you would think that it would be on the city, your claim most likely is going to be against that business.
Okay, so the business has to maintain the sidewalk in downtown Mobile.
Right, yes. And again, the case we had was where it was a tree that is probably 20 years old, and it had grown and it had broken up the concrete, and there were a lot of leaves on the ground, and my client couldn't see that there was a uneven concrete, and she fell and again suffered horrible injuries. And so we naturally just made a claim against the city, and the city's like, not us. You got to go after the company. And sure enough, in their agreement, that's what it was.
So how would contributory negligence play into that if you're going for a jog downtown
Right.
and you trip and fall? Did you just contribute to your own accident and you don't have to claim anymore?
Russ knows more about contrib than anybody, but in a situation like that.
No, I mean, it's going to come down, just like in any case, it's going to come down to the facts of that case. But, and again, kind of like Bill said earlier, you need to take a photograph of whatever it is that caused you to fall. And unfortunately, well, I say unfortunately, depending on what it is, how big it is, how obvious it is. There was a recent case that came down from the Supreme Court a couple weeks ago that actually is helpful in that regard. It involved a hole in a parking lot, a fairly decent sized hole, and in that case, a trial judge had ruled as a matter of law it was open and obvious. Therefore, if you step in it or if you tripped on it, you're out of luck. You should have seen it. And the Supreme Court said, no, that's not. It's going to be a jury question, and you have to look at it. So it's just real fact intensive. It's how big it is, what is it that saw it, like in Bill's case,
Right.
You've got leaves that are covering it up. There are a lot of things that go into it.
And again,
and ultimately it should be.
Right.
If there's a question, then that's what we have a jury for.
Mm-hmm. And again, we always talk about what contributory negligence is, and I think a lot of people, they probably don't necessarily understand what it is. Alabama, they operate their civil justice system on the contributory negligence theory, which means if the plaintiff contributed to his or her accident in any way, shape, or form, even just a little bit, even 5% or 2%, then he or she gets nothing. And it's not like that in other states. It's comparative negligence. Say, if you're 10% at fault in Mississippi, and the judge or jury rules that you're 10% at fault, then you only get 90% of what you normally would be awarded. In Alabama, if you're 10% at fault, you get nothing. And so what Russ was talking about, it's, as far as open and obvious, if you're walking down the aisle in a grocery store and you see a puddle of water and you decide that you're going to walk through that puddle and you'll be careful and you fall and you break your leg, you don't have a case because you knew there was a danger and yet you decided to go through it anyway.
So what the Supreme Court is saying is that now more of these cases, it should be up to a jury, not a judge.
Yeah, and
not a judge saying, okay, that's open and obvious.
And I'm not talking about a puddle of water that you see.
Right.
I'm talking about maybe there's a puddle of water there and you don't know it's there, but maybe it's as it's as big as 2 dinner plates or
Right.
Their argument, the defense argument, is you should have seen it. You should have been aware. It was so large, so open. You should have seen it. And the Supreme Court recently, in a recent case, said, no, look, slow the roll there a little bit.
Yeah.
And you know, it's not as a matter of law. We're going to look at the facts, going to look at everything, and let a jury decide.
It kind of opens the door a little bit to what
Right.
the complaint that I mean, you've brought that complaint up a lot. I mean,
Right.
if you're just a little bit at fault, you get nothing. So it kind of opens the door to maybe revisit that issue.
Yeah, and like Russ said, it's not a matter of law. It shouldn't be a matter of law that they just throw the case out. You know, a jury of your peers should decide whether you should have seen it or not.